I am Holden Mobley, and I am the attorney representing George in this issue. And you are?
Mark Butler, and I represent Martha.
Perfect.
Well, I don't really know how to get this started, but we obviously recognize that the arbitration agreement that was composed by both of our parties and signed has some, for lack of a better term, some squirrely language that I guess we need to discuss. The arbitration clause, although the divorce decree is binding, and typically the arbitration clause, if there were one that's included in a divorce decree, that's binding as well. But I can tell you that the first main problem that I see is that the dispute which gives rise to us even meeting here and even engaging this arbitration agreement is a dispute about the children.
Correct. That's how I also interpret it.
Okay. And given that it's about the children and it's a family law matter, it seems from the research that I've done that that the FAA, that Martha and George specifically stated that didn't apply to them because they weren't active, they weren't acting in interstate commerce. Because it's a dispute about the children, I think that the dispute actually implicates the Uniform Family Law Arbitration Act, which is spawned from the FAA, as you're well aware.
Correct.
And under the Uniform Family Law Arbitration Act, it's generally similar to the FAA. It takes a lot of its guidance from the FAA, but it specifically identifies that that the agreement on its face must identify the arbitrator, an arbitration organization, and a method of selecting the arbitrator. So the first thing I would like to point out is that I don't even think that, based on this language, that the arbitration clause is even valid, to be quite honest.
Well,
how do you feel?
Yeah, I agree in the sense that I also believe this arbitration clause is most likely, void, invalid, however you wanted to describe that. The interstate commerce issue is one that we need to talk about. The Prima Paint case talks about severability.
Right.
And that case was a little different because basically, the arbitration clause, was separated from the whole contract. And so we only have the arbitration clause here. We don't have the entire divorce contract or agreement. So I guess, my point of bringing that issue up is that, there's a chance that certain parts of this agreement, paragraphs even, could be, separated. I believe, as far as what the court determined in that case, when a contract has a broad clause, which is this is a similar
right.
fact, this is a super broad clause, not tons of specificity, then, we'd have to kind of look at, is there any sort of fraud, which I don't believe there is. I wouldn't argue that. But if certain parts of it should be rescinded, it should be, void, or if the whole thing should be void. I think there's some of the issues. I think probably the best way to look through this arbitration agreement for you and I is to go through what are the, as you call them, squirrely terms,
right.
and kind of go through. An arbitrator can't make decisions based on child custody, to my knowledge.
Right. No, I agree with that.
Family law and the state law preemption kind of issues. Because, like you said, even if the FAA, like a federal regulation, doesn't rule over this, state law something will have to rule over this arbitration agreement. You and I can't just, make something up, make laws up and just abide by them.
Right.
That's not legally enforceable.
So if I hear you correctly, you're saying that if we determine that this arbitration agreement is void, then state law is going to determine the outcome of any dispute that arises between Martha and George relating to their child. Do you agree?
Correct.
Okay.
Yes, correct.
I mean, because that's how I'm reading the statute as well.
And you and I both know, family law is a state law issue.
Right.
That's something that state law, there's federal regulations or acts or certain things like that, similar to arbitration, acts like the FAA, but there's no really set precedent that's federal for family law. State law usually governs how courts rule in family law issues such as child custody or anything like that.
Right. I totally agree. One thing, though, I did want to point out is that I don't even think, regardless if their language says that the FAA doesn't apply and other certain regulations don't apply, I don't think just by stating something in a contract, even if the contract's binding, makes things correct or makes things real. At some point, there has to be a governing body.
Absolutely.
And so I think what I hear you saying, and we're both agreeing that state law, if this does not, if this is proven void, state law is going to control, and it's the state judicial system, not a state arbitrator or anything. It's going to go to court.
All right, I agree. Yeah. Well, I think that that's going to be one of the major issues as well as for this whole case, this first part, and then when we talk about the child custody issues, is just simply that. Right. What after you decide, okay, the state law governs or blah blah blah, anything in that sense, then what sort of reason would we have to maybe go take this to court, or what sort of reason would we have to just sort of you and I figure out this negotiation about the child custody issues, present it to our clients, and then agree upon that? What would be the sort of reasoning, or that I think that's one of the big things we're going to have to decide here. So I guess one of the things in the arbitration agreement that you and I should discuss again. One major point is this agreement says nothing about, like you mentioned, what jurisdiction does control.
Right.
Where this arbitration will occur or will take place, under what laws, or just, physically, in what state, in what area, where it'll happen. It doesn't rely on any sort of federal guidelines. There's just hardly anything here in this agreement that points to any sort of jurisdictional or legal precedent or use, at all. It's just that's a major flaw and problem in this agreement to arbitrate, in my opinion.
Yeah, I totally agree. If you don't mind,
yeah.
With your permission, I'd like to at least go through the clauses that are stated in the original agreement. And these are clauses that
That's
are
what you have in front of you right there.
That's
I have it in
correct.
front of me as well, the agreement to arbitrate.
So these clauses that we're going to discuss are in the event that there is some unresolved matter relating to this divorce. And a lot of them we've kind of discussed broadly already, but one main one that I really want to just, at least I want to read it to you, tell you what I think, and then maybe get your opinion on it. It says, there's a clause that says, whichever party initiates arbitration shall have the burden of proof. That's kind of part one of this statement.
Right.
Imposing...
This is the third paragraph, this is the third paragraph of the agreement.
Correct.
And that you're reading right now.
Right. And then it states, in imposing this novel variable in the agreement, the couple, George and Martha, herein declare their intention to spice up the possibilities regarding any disputes down the road. The reason is to inject a disincentive to the use of binding arbitration. I'm not exact, my confusion is not really, this is not a legal argument, But if there's wording on this second part that's in the contract, in the arbitration agreement, that specifically says it's to disincentivize anyone to use binding arbitration, my question would be, why did George and Martha ever put it in there? It really makes no sense. It's counterintuitive to an arbitration agreement on its face. And then the first part of this clause, it says whichever party initiates arbitration shall have the burden of proof. Now, I don't think that clause in and of itself makes the contract voidable, but I'm certain that two parties cannot contract around who shares the burden of proof or who holds the burden of proof given the dispute. The dispute that is right. What gives rise to who has the burden.
Right, I agree with that statement. That was another issue that I had, that the burden of proof it will be determined by some sort of governing body, some jurisdiction, state
right.
law, federal law, whatever, ends up winning in that argument. But that two humans can't decide, jurisdictionally,
right.
That's not allowed. I agree. That I had also question marks kind of written down in my margin for that issue, because it seems to flip-flop from the beginning
right.
of the paragraph, like you said. It talks about the exclusive remedy and mechanism of enforcement for binding arbitration, and then the last sentence, talks about disincentivizing the use of binding arbitration. So it just seems like they're all over the place. Like they don't really have. They're saying they must use arbitration, and then they're saying, but we can decide that we don't want to use arbitration at all.
Right.
And that just. So I guess maybe we could, send them back to discussing this contract and deciding together
right.
if they would wish to, rescind this contract. This clause or agreement to arbitrate completely, because it seems like they're not totally sold on whether they want to arbitrate or not anyways. One point that I wanted to bring up, just that piggybacks on what you said, was I wrote here in my margin that parties are, only legally obligated to arbitrate disputes that are mentioned specifically in the agreement. But this agreement doesn't necessarily have specificity, as I mentioned earlier, about what disputes would arise, especially for this certain case of child custody.
Right.
It's very broad. It's too broad almost. There's not, I know that courts have also, there's been cases that we've studied this semester that have talked about sometimes if it's too specific, the courts keep, in the FAA especially, courts usually, make arbitration agreements broader than most contract agreements. But I just think that there's nothing really here in this arbitration agreement that specifically speaks to potential, further disputes they could have that would make it, an arbitrator be able to, legally arbitrate this. It's hard for me to find examples, specific examples that the arbitrator could, that could satisfy the FAA, for the
right.
question.
Well, also related to the issue that you were just talking about, how it's not specific, and typically an arbitration agreement it doesn't have to be specific, but it does have to have some type of mechanism for certain issues, and obviously this is generic. When George and Martha stated that this agreement is not affected, controlled in any way, shape, or form by the Federal Arbitration Act, they did this under the guise that it's because their marriage nor their divorce has ever affected interstate commerce in any way. And although I agree with that, an argument could be made in this case that the dispute arose because Martha wants to take the children out of the country.
Correct.
That dispute does affect interstate traveling, traveling across state lines. It's not specifically intrastate. Now, that may be a very small sliver of an argument, but I think it is at least important to bring up because that's what this child parenting plan issue is really why we're here. It's not about things that the FAA could control, like property settlements or the way that we've decided to maybe interact with each other or something like that in our divorce decree.
No, I agree with you on that rule. You know, we're talking about all these sort of specific clauses and issues, you know, just as a public policy point. You know, I have here written in my notes that sort of the Mitsubishi Motors Company corporation case that we studied this semester basically, you know, was ruling that, you know, there's a broad national policy sort of that favors arbitration, and also the need to protect parties' freedom to choose. So I think that, you know, there are also arguments that, you know, a court, maybe someone could agree that this would be available, you know, like that this could be binding. I just think that, you know, overall there's just a lot of holes that, you know, little parts that could, you know, potentially make it null and void. Again, going back to what you just talked about with the interstate commerce issue, you know,
I really don't think that's an issue.
Okay, well,
I just don't think it's controlling, only because I think even if the FAA doesn't control, and it doesn't apply, regardless of what they said in this agreement, then there are other controlling bodies like the Uniform Family Law Arbitration Act, which there again, it doesn't have anything to do with interstate commerce, but the rules of those uniform acts are the same when it comes to arbitration. There needs to be, although I think Georgia Martha had the ability, they're allowed to come up with some general arbitration agreement. I think they both failed by not seeking real legal advice because they didn't even get the big parts right. And that's really why we're having such a difficult time just deciding or discerning what's valid. Is the whole thing crap? Is it, or can we save any of it?
Right. And I guess that was a point that I wanted to bring up. I know you just kind of brought up the interstate commerce issue, but then you agree that it's sort of an ambiguous kind of way of looking at this because this is a family law issue where kids are potentially moving, you know, state lines, country lines, blah blah blah. But you know, I'm not sure if it totally affects commerce in the definition of that. I mean, you could argue it, but it's sort of.
I agree.
But you know, this sort of the FAA preempts state law usually, you know, unless it is purely interstate. So that Southland versus Keating case that we had, it mentioned that it was basically just saying that, like I stated, that if it is purely interstate commerce, then state law is not preempted by the FAA. But if it isn't, the FAA usually preempts state law in these kind of cases. So I mean, I guess it's just goes back to, again, speaking to the sort of wish-washiness of the arbitration clause in general, that it says the FAA does not at all, you know, that it's immune from the arbitration agreement. In the last paragraph it says that word for word. But then it, you know, and it basically says no federal law would apply at all. And that's usually true in child support enforcement regulations. I mean, in one sense. I mean, although that's not totally true. I mean, usually federal regulations are used and understood and read and sort of given deference. And even if it's a state law or state law case, you know.
Well, I think we've got two issues. I think the arbitration agreement, typically the federal regulations of arbitration will preempt state law.
Right.
Basically stating that the FAA controls, right? And we both agree with that. However, the cases that we've discussed, they have to do with commerce. This is a family law dispute. So my belief, and I think it's yours as well, and tell me if we've discussed this already, but because this is a child-related dispute, that under the Uniform Family Law Arbitration Act, it specifically forbids an arbitrator from determining any dispute relating to the child.
Right. That's I mentioned that earlier.
Okay.
I agree.
Now, obviously, we're both aware that recent trends in some states do allow it. However, given the lack of specificity in ours, I really do think that, at least if nothing else, it's something to consider. So let's, if you will, let's go down this state law controls or the state courts control road, assuming that for our dispute, this arbitration
They've
agreement
written out the FAA, and so let's just go, right.
And you noticed, as well as I did, that...
Although I'm not sure, again, I just want to make this point, I'm not sure if you can write out the FAA in this arbitration.
Right, I totally agree.
I'm pretty sure that the FAA is what makes these arbitration agreements binding.
Right.
Legally,
Right.
But just for
that's
the
what I
sake
feel.
of
That's how I
argument,
feel too. Okay, so there's also a state law that we have in our jurisdiction that says no contract can bind the parties to it if any part of that contract materially represents clearly established law or laws within the contract itself. Any contract having such a legal misrepresentation shall be declared null and void by a state trial court. So given what we've discussed, generically speaking, if you take it all as a whole, it seems like this contract materially represents clearly established law because the FAA is clearly established law. Even though the Uniform Family Law Arbitration Act isn't a law in the sense that it controls, it does offer guidance to the states. So if the state courts determine family law issues as well as have a law that states that a contract that says that, like we have here with Martha and George, that, hey, we can just write out, if we expressly state that those laws don't apply to us, then they don't. I think that falls flat, especially given this statute. And then the second part of the statute that says any contract that does have that legal misrepresentation shall be declared null and void by a state trial court. I'm under the opinion that if we move forward, you and I, in this dispute, and we push for arbitration, that not only will, it's so ambiguous that the only way we can get any kind of support determine the validity of this agreement. So even though both of our clients wrote out expressly that they didn't want to go to court and didn't handle these matters, they wanted to do it privately with the arbitration clause. If our clients cannot agree regarding this child dispute or child custody dispute, I think they're still going to have to go to court, because the first step would be a court determining the validity of the agreement before anyone can determine anything regarding this dispute. So if they want to stay out of state court or federal court, if they want to stay out of court in general,
they're going to have to get together.
They're going to have to get
together. They're going to have to agree that they're going to have to rewrite a new agreement to arbitrate that is more specific, that talks about what jurisdiction controls, that talks about, who is the arbitrator, or how do we figure out how we determine the arbitrator, and where this will happen, and that the FAA is going to have to rule. I mean, it's going to have to guide this arbitration agreement.
Right.
They're not going to be able to. It doesn't really even help them necessarily to write out the FAA of this agreement. I mean, in one sense, I don't know why they even did that. The FAA should should be what the, you know, the body that controls this agreement, like for them. It would, I think, it help their case if they truly wanted arbitration for these issues. Now, that's, you know, a bigger question. I'm not sure if they, you know, really knew what they were doing when they were writing on these documents. But I mean, I agree with what you're saying. I agree with what you're saying. That they're going to have to come together and agree on rewriting, first, you know, rescinding kind of, you know, this contract, this clause, you know, if it's part of a bigger contract, and rewriting a new agreement to arbitrate. Because unless we get that, we will have to go to some sort of a, you know, judicial board, you know, court, whatever you want to call it, to figure out whether we can even, you know, hold this arbitration clause valid. There's just so many glaring issues.
Right, I totally agree. I mean, what I think both of us are agreeing to is that this arbitration agreement is so vastly void of any discernible specificity as to what it covers and what it doesn't, that the best move for both of our clients is to really, before we even get to the dispute of the child, they need to get together and just discuss how invalid this thing could be and the ramifications of such. Because I think even though you've stated, and we both know that U.S. courts almost all the time hold arbitration agreements valid for the most part.
Right.
They've got broad authority.
It's broad.
They grant broad authority. There does exist in all the statutes, whether it be the FAA or any lesser statutes, that any grounds exist at law or in equity for the revocation of any contract. So even though they want to enforce them, if this is so unequitable or inequitable, it just kind of flies in the face, I think, of just regular good faith contract law. There can't be ambiguities in contracts. There's got to be, both parties kind of got to know what they're signing. And I feel like it is so ambiguous because they were trying to be so crafty that I don't even think either party knew what they were saying when they said it. Because in law, obviously, words matter.
Right.
And when you take the plain meaning of words, or when there's ambiguity, you just have to take the plain meaning. And when they put in words that talk about disincentivizing other parties, I mean, I just think that contracts are normally not, they don't impute some kind of, not, I won't say limitation, but some kind of negative effect.
I
don't know if I said that right, but
I think I understand what you're saying.
Okay.
And I guess one point, just to play devil's advocate to what you just said,
right,
is that I agree with you that usually courts read arbitration clauses to be broad, and they usually try to accept courts don't want to really have to deal too much with arbitration clauses. That's the whole point of having an arbitration clause, to stay out of court, to stay private, to be quicker, then maybe a court case would be less expensive, blah, blah, blah. And so I agree with you that's the case. As far as contractually, I agree with you too, that this, as a contract, I'm not really sure if it even is a valid contract, but I will say that there's not a ton of wording, again, a lack of specificity, that is fraudulent or...
Right, they both agreed to it.
Right.
They both signed it.
There is a truth to that. It seems like they were both two parties at the time who wanted to come up with a valid agreement to arbitrate, and sort of that sort of subjective theory of thinking about what the client, a reasonable person in this situation, what they were trying to do, that could hold some weight in a court issue. But my interpretation of this whole deal is George and Martha, my client George and client Martha, were getting a divorce, and they, for lack of a better, whether it was being private, whether it was money, whatever the reason was that they decided to do all this on their own, kind of, legal Zoom or whatever, entity they used it on, was that they wanted to find an agreement to arbitrate, write one up, create one, but that, they just sort of quickly did it, and they really weren't, they didn't really know how to do it. And so I think that if we get them together, and both, counsel them on that issue, and maybe give them some tips on how to correctly write up an agreement to arbitrate, or you or I write up this agreement to arbitrate, that, they could be better off, I don't know, it just depends on what they want to do, but I think that they could easily fix this, but they're, like you said, they're going to have to get together and fix this.
I totally agree.
This is not going to be an issue where, oh wow, the agreement to arbitrate is null and void, or blah, 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 or it's totally works, and no one's going to argue that. I think my party, George, will argue that some of this stuff shouldn't happen if we have to go to some sort of an arbitration over this. There's some issues here, so I think that both of us maybe want to get together and find a way to meet common ground on this.
I'll totally agree. So we both agree that it's highly likely that the arbitration agreement is void. If it's void, state law controls. Or at least this is what I think. The family law issue is going to be decided in the courts, which was originally why they even had an arbitration agreement. And I guess what brings us here today is the issue with my client wanting to take the children to Beijing for 6 months.
Right.
Obviously, between you and I understand that that's a long time. But the arbitration agreement aside now, I think you and I just need to flesh out certain, hopefully, we can come to some kind of middle ground on this issue. And let me first state that it seems like both of our clients had the same intention when they got divorced. And they've been divorced how many years now? At least 4, I think.
Right.
But I mean, that's not that big a deal.
Right.
But when my client is basically upset because she feels like when they did get divorced, they had an understanding, and they were both they both found it important that their kids would be able to experience non-Western cultures. And now that Martha has got the opportunity to go to Beijing for 6 months, and almost like a study abroad, if you will, for the kids, or at least treat it that way, she's really just upset because she doesn't understand why your client won't agree to it. Although, on its face, I do understand that 6 months for any parent is a long time to be away from the kids.
Right. So, my client George, you're right in insinuating that my client does not want these children, for 6 months, to a year, to that long of a time to be, in China with your client and her new husband.
What are his, if you don't mind me asking, what are his main concerns? Because obviously the request was that before this became a dispute that involved us, generally, or generically, she just asked if she could take the kids for 6 months. He said no. But why? Like, what are his reasons?
So
the main reasons.
So the biggest things for George, my client, number one, we have a son, Milbank, who is very, George sees him as basically a terminally kind of ill, or just sort of a child who will always need some sort of help educationally, and he's still at the age where he needs that help. You know, recently we've got him in this IEP program in school to help him, and he's been doing better. He's been doing well. He's happy, he's successful, he's healthy, and all of a sudden, just months after, you know, he kind of finds this moment of clarity where things are starting to become a little bit easier for him after all these years of, you know, wondering after, you know, the ADHD, what's wrong with me, how come I can't get along in school, blah, blah, blah. Then we just uproot him and move him, you know, to China, exactly what it will be like. I mean, you and I could both have an idea of sort of, you know, how successful or unsuccessful that could be, you know, when we'd probably be on, you know, further ends of that spectrum. But, you know, I think that we can agree that we don't know what it would be like. And so George is really concerned about Milbank. You know, he's really concerned about his health and his sort of educational changes.
So his main concern is not for all three children, it's really just for the youngest child?
Well, I wouldn't say that exactly. The problem is that Giorgio, our oldest, he's 18 years old. So he has the right to do whatever he wants to do. He's a legal adult. You know, he doesn't have to go with you. He doesn't have to listen to me. I mean, when you're 18 years old, he's going to junior college in the fall. You know, he's free to move around and, you know, do whatever he wants to do.
So your client's okay with Giorgio going?
Well, yes.
Okay.
I mean, I'm okay.
Well, I mean, he at least
Giorgio's
submits
going to make his own decision.
Okay.
I think this issue really is about, you know, Sriracha and Milbank.
And I get that they're younger. They're a lot younger. I mean,
Correct.
10 and 11 years old, they're probably in third or fourth
Well,
grade.
Sriracha's about to change to middle school with her
So
friends in
yeah,
elementary
sixth grade,
school.
I guess.
Yeah.
And I understand that. But if the main reason that your client doesn't want them to go is not the longing, if you will, or the missing them, if that's not the controlling motivation for him not wanting them to go, I would at least like to offer the fact that Beijing has an excellent school, that my client will look at when she gets there. She's also not going to be working for 6 months. So it's possible that she could actually homeschool. And if Milbank, if the main concern is Milbank and his deficiency, if you will, or this it's ADD. It's not anything that you and I didn't have when we were in law school. So it's not like he's got cancer. It's not like he's terminally ill. He's just a young boy that's hyper, that does have I'll submit that he's got a learning disability, evidenced by the IEP that he has to have. However, my client has actually talked to some teachers, and they're generally supportive of the decision for him to study abroad. That they think he can make it and thrive in an environment like that, given the right circumstances. Are there any other concerns as it relates to
China,
his disease or his condition? And that's not a disease. Sorry.
Well, I don't think that it necessarily, you know, any other major concerns as far as his condition, but I can't really overstate enough that this sort of abrupt change, you know, to a totally different, you know, geography of the world, whether it's the temperatures or just the, you know, parts of the country as far as cleanliness or just what he's used to, you know, all those things can either positively or my client believes negatively affect someone with this level sort of this condition, you know, and so I guess the biggest concern is just to make sure that this is the right steps, you know, and that's I mean, I think that's a very logical concern. I don't think that teachers or other adults in the community's opinion about the safety and well-being and welfare of my child, you know, of George's child, you know, therefore, should have any precedent over George's own, you know, opinions of those things. I mean, George and Martha together are the parent for this child and have been helping him and paying for all of his medical needs and, you know, working on all of his emotional and physical needs their entire lives. And I just think that, you know, I don't think that necessarily we should hold too much weight with his, you know, teachers, all his teachers' recommendations.
Well, and I understand that, the feeling that he would have, but you do realize that my client has sole legal and equitable custody of all the children that was agreed to in the divorce agreement, and that George only has visitation every other weekend.
Thursday through.
Right, and then certain breaks, he's got them. But I guess my argument or my contention is, so we'll go down a couple of different roads. If Martha leaves, if she goes to Beijing with her husband and leaves the children here, is your client even suited to take care of at least the two younger ones full-time for 6 months? Because it's not something that he's ever been used to, and it doesn't seem like it's anything that, although he's successful in the parenting plan that they currently have now, is that something he really wants to do? And then the other, I guess, question would be, does he even have the right to, well, let me state it differently. So if Martha leaves and goes to China, she leaves the kids here, that's one option. Another option could possibly be that she goes and takes the children and therefore breaches this custody agreement, and there could be some kind of legal action that you and I could discuss, which
yeah, and if she
I
does
don't
that,
think it's,
we'll be in court and litigation.
okay, and I get that, I understand, I'm just offering an alternative.
Right.
The other alternative would be my client takes the kids with her to China and then puts them on a plane every other weekend and on the breaks that you're legally required to.
Okay.
So,
well, let me give you a few opinions about that.
all right.
Number one, again, the biggest thing for me is the welfare of the two young children. You know,
Sure.
Sriracha and Mobley. You know, and if we can't come to, you know, some sort of agreement, I just don't want them. Ultimately, I would rather. I think my client George's, you know, take on this would be that he would rather see the welfare of them, you know, kind of ruling over his own, you know, personal opinions or feelings
Right.
toward Martha and this whole issue.
So if Martha takes the kids and sends them back to him for the what he's legally required to get for visitation, is he okay with that?
Yes, under some conditions.
Okay, what were those?
Like one condition, for instance, that my client would like is he was going to Cancun for the whole month of July. He usually has summers with them, like on trips in the summer.
Right.
And the kids, you know, would be heartbroken to lose that sort of interesting, again, another international, different cultural trip. If that's sort of what Martha and George, you know, want to, you know, instill in their children. And my client would really enjoy being able to have them on that trip to Cancun. That's one issue that I believe my client would like to have.
Okay.
He's renting a condo in Cancun for the month of July. And that's the time period that he would like to. That they will be out of school at that point, you know, as you understand.
Okay. Well, would he be willing to, if Martha takes the kids and sends them back for this, whatever time he's allowed during the 6 months that my client's gone and has them, is he open to, if he's open to receiving them on those times, is he open to paying for the airfare?
I know.
You think that's a stretch?
Well, I think that my client would be willing to split the cost of airfare. You know what I mean? Basically,
No, I get it. Yeah,
basically
and I think that's
have-
fair. I don't know. I think obviously we need to come to some kind of agreement, and I think that's in the best interest of both of our clients and the children. However, with my client having the sole legal and equitable custody, I just don't think George has much legal standing if my client puts him back on a plane and he is not, his time that he's allowed is not limited. I just don't think he's got an argument there.
Say that again.
If he still gets his kids for the time period that he's always gotten them, and it states in their divorce decree that he gets them, being that Martha has sole legal and equitable custody of these kids, she can make all decisions for them that she wants to. They don't have joint custody. They don't have joint physical custody and then some financial arrangement otherwise. So my contention is that if Martha does that, takes the kids, sends them back for the time period that he's allowed, and he splits the airfare, would he agree to that?
And he splits the,
So basically, he's still getting his visitation. The only difference is they don't live in the same state. They live thousands of miles away for 6 months. And the reason that my client feels that it's important is because at one time, both your client and my client shared the exact same goals for their kids, and that was to, I think specifically, she just doesn't understand why at one time he thought the best interest of the children was to expose his kids to non-Western cultures, and now given the fact she's got the opportunity to spend 6 months in a rich cultural city like Beijing, now he, for whatever reason, which she doesn't know, and I'm trying to determine why he's bent on not letting them go or not wanting them to go.
well, I've stated some of the reasons why.
Well, most it seemed to have to do with, there was one statement about Cancun, we've solved that.
Yes.
There was one, the statement about Millbank, listen, it's not something that he can't get. One accommodation, if that's a concern of yours, is that we can either take a 6-month supply of Adderall with us, or you can get his prescription filled every month and mail it over to me, or mail it over to my client so she can make sure that that Millbank is medicated properly.
Here's one thing I want to bring up for my client's sake. Millbank needs to be on some sort of educational program over there that is an IEP similar or variation course. I'm not comfortable giving my clients consent to sending Millbank over there and just having regular visitation rights if knowing that he's changing schools and his educational programs are drastically changed and abruptly changed by moving to China. There's nothing that our parties know of yet that's for sure that he'll have the same level of education in these schools. My client would like to have more, sort of information on these schools and understanding that Millbank will be able to have a similar IEP type program over there in that school. Otherwise, my client would want Millbank to have some sort of a, either tutor or homeschool issue where he's getting the protection educationally and sort of socially that he needs and wants.
Well, if we can provide that, if we can provide that,
I didn't mean to turn the lights out.
3 minutes. If we can provide that, would your client agree? So, are you saying that your client's biggest holdback or reason for not wanting them to go is simply because of Millbank's educational needs? It can't be his medication, because we can solve that problem. If it's education, there's definitely an excellent school that can provide him with the education that he needs. And not to mention the fact that even though he's on an IEP, he was on that IEP before he got before, now that he's been on Adderall, he's a little more focused. I mean, it's arguable that he's doing better. He's doing better because of the medication, not because of the IEP and them taking him out of class every day, and making him read, books on tape or something.
Well, so my client disagrees with that assertion, just simply in the sense that, the Adderall and the medicine helps, but the IEP program, I mean, is, sort of abruptly changing that would be a shock to someone who deals with anxiety and deals with, social issues and deals with not being able to focus and attention deficit disorders. I mean, things of that nature. I mean, sort of changing what they're used to and kind of putting them in a totally new environment would do nothing to, neither you or I are doctors, but
right.
would do nothing to help that. I don't believe my client would be able to agree, on that statement. I think that, what if there was some sort of homeschool, situation?
She's open to that suggestion.
Where teachers could somehow send lesson plans or send some sort of, mirroring of, what they're doing in school now to basically help facilitate this change for my client's children, both Sriracha and Millbank, so that it's easier for them, so there's less confusion, hardship in the transition period of moving from American to Chinese culture, which would be hard for anyone, especially 10 or 11-year-old children.
Well, I think China is a very culturally rich city. There's a lot of tourists there. The school that I mentioned is an American school, so I don't think that should be an issue. Is there something else? Is there something underlying that we just don't know that the holdup is? Because if we've made the accommodation where, I mean, it is expensive to send these kids back and forth. Mm-hmm. However, I think my client would be willing to do that if the costs were split, given the fact that both our clients are very successful. I don't think money's the issue. I think her necessity or her desire that they're exposed to some non-Western rich culture definitely weighs heavier in deciding that, yes, she would just take them, and although she doesn't want to send them back, she doesn't even want them to go to Mexico because they don't want to go. Or they've told my client that they don't want to go. But she'll send them back if your client will just agree that based on all these accommodations, he's not going to miss out on any time with his kids. They'll be exposed to non-Western cultures, which he really wanted at some point. It seems like the sticking points would be the educational program. I get that. I do.
That's a big thing for my client. That's a major issue.
Okay, given that that's the case, is that the biggest issue?
If we could figure that issue out, then my client would agree to the other terms as far as splitting the cost of flying the kids, back and forth. Okay. We could even come up with a different plan to make it easier for them, maybe twice a month or something, and then having the full month of July for that Cancun trip.
I like that. I like that idea. I think my client would like it.
So it's less frequent every, or whenever it is, but just less frequent than, every other weekend or every weekend sending the kids. That would be a little tough for the kids. My client, I don't think would necessarily.
All right. What about this? Because my client has not yet, although she's heard that school is excellent there, her plan was to not tour the school or even investigate the school until she got there, until she arrived in Beijing. If there's a way that she can kind of preemptively do that beforehand and provide you with assurances that Millbank, it's not like my client wants the worst for Millbank, she actually thinks this is going to help him. So I think both, at least I speak for my party, has the best interest of her child in mind when she's making this decision. So regardless if it's homeschooling by my client or this exceptional school that is located in China, in Beijing, if she can provide you with maybe the programs that are offered there, whether it's via Skype or materials that the school has, or references from other students and maybe administrators of the school, do you think your client would then agree to allow it?
Allow them to go to the school.
Allow them to go to Beijing.
Right.
If that's really the sticking point, is Milbank's. It's not his medication, it's not his condition as much as it is. He doesn't want him to fall back. He doesn't want him to regress.
If y'all's party can prove that Milbank will have an educational program that catered to his needs, you know, specifically, and that my client can receive sort of proof of that, you know, and that is truthful and not, you know, dishonest or fraudulent in any way, then my party would agree to allowing the kids to go to Beijing with their mother. Let's say, you know, once, maybe twice a month.
We'll fly him back twice a month.
Does that seem reasonable, or does that seem like
Twice a month
much?
would be every other weekend, so it's kind of like what we have now. Right now, you've got every other.
Okay, well then let's do this. Let's do once a month. Oh no, let's keep it like we have now.
Okay.
Twice a month. Flying the children back, we'll split the costs of those flights.
All right.
And the children will come back earlier than the desired end of the trip to make the July month-long trip to Mexico.
The trip to Mexico is for 1 month?
Yeah, it's in the month of July.
What's the duration of that, though? Well, you're obligated, or not obligated, you're allowed 8 weeks in the summer, so that's plenty of time. That's basically the whole summer.
But my client needs the month of July, because that's when he's got this condo rented for, you know.
That's okay. My client would agree to that. I mean, even though she doesn't want to, I think she would, because it's important to her that her kids experience the richness of culture.
And then what about one more thing for my client is that we have some sort of whether it's Skype or some sort of relationship where we don't have to have, it doesn't, you know, but where Martha and, you know, my client speak, you know, once a week, or my client gets to speak to his children once a week.
He can call them any day.
Okay.
How about that?
Okay.
By phone call. I mean, I don't think there's an expense to that. But if you want to put that in the agreement,
let's put it. Just make sure that once a week there's some sort of a Skype session where the children can see the father, and George can basically get updated from Martha as far as make sure the schooling for Milbank and everything is going smoothly, and Sriracha as well.
Okay. Yeah, let's not forget about her. All right.
Okay.
I think they'll agree to it. I'll write this up and send it over to your office for you to sign.
Okay.
You think that's good?
I believe George would be happy with that.
Okay. All right, good deal. All right. Nice to meet you, sir.
Thank you.